Our mission today is a deep dive into the verified public record concerning the later life and death of financier Jeffrey Epstein.
Right.
We are not here to speculate. We're here to trace a narrative of documented institutional failure.
Exactly.
We're focusing specifically on the negligence, the documented misconduct, and, the forensic inconsistencies that are detailed in official reports and court filings.
And that timeline spans everything from his initial charges right through to the end of his time in federal custody.
It is a profound and, frankly, a very unsettling subject.
It is. And the central tension that really anchors the entire public debate around this case is a simple, verifiable fact.
Which is?
How did an inmate who was designated as high profile and high risk detained at the Metropolitan Correctional Center, the MCC?
A place engineered to be one of the most secure federal jails in the entire country.
How did he die under what was indisputably a catastrophic set of documented security lapses?
So our analysis tonight, it's going to rely exclusively on those confirmed, publicly reported facts.
That's the only way to do it. To unpack the staggering layers of institutional collapse that both preceded and surrounded that final fatal event in August 2019.
Okay, so the foundation for this deep dive rests on verifiable institutional documents. We're talking about the extensive reports from the Justice Department's Office of Inspector General, the OIG.
Right, the OIG reports.
Also, detailed court records from the indictment and eventual conviction of his associate, Ghislaine Maxwell.
And of course, the huge amount of documentation from major media investigations. They've really systematically outlined that sequence of institutional failures.
Right, starting with the initial 2007 agreement and just culminating in that final custody lapse.
So to really understand the weight of these failures, I think we have to start with the immediate sequence of events.
The final hour.
The final hours of negligence that allowed this to happen inside the federal prison system.
Let's establish the confirmed, verifiable facts regarding Epstein's final incarceration at the Metropolitan Correctional Center in August of 2019. He was placed in the Security Housing Unit, the SHU.
The SHU, which is a section of the jail generally reserved for inmates who need maximum protection or who are considered serious security risks themselves.
And the protocols for any inmate in the SHU, they're rigid. They're non-negotiable.
They're designed specifically to prevent incidents just like this.
Exactly. For an inmate with Epstein's profile and his placement, there were two key requirements mandated by the Bureau of Prisons protocol.
The first one was that he had to have a cellmate at all times.
At all times.
It's a mandated safety measure. It's often called suicide watch adjacency, even though technically he wasn't on suicide watch at that specific moment.
Right. And the second requirement, equally vital.
A guard check. Mandatory every 30 minutes through the night to ensure his well-being and security.
And the public record shows, unequivocally.
On the night of August 9th to the 10th, 2019, these procedures weren't just bent, they were violated. Immediately and completely.
And this violation, it started early in the evening. His previous cellmate was transferred out.
And critically, no replacement was brought in.
Despite the mandated protocol, that single decision placed him in an unsupervised environment, which was completely contrary to his designation.
The records show he was escorted back to the SHU at 7:49 p.m. The guard was Tova Noel.
And from that precise moment until he was discovered the next morning, the layers of mandated supervision,
They just disintegrated.
completely.
And this is where the documented failures of the detention staff, they become the factual basis for that deep structural skepticism that followed.
The two assigned guards for that critical overnight shift, Tova Noel and Michael Thomas, they didn't do their jobs.
Not even close. According to the federal investigations that followed, they reportedly fell asleep at their desk.
For approximately 3 continuous hours.
3 hours during the night.
And the lapses weren't just sleeping. They failed to perform the required institutional inmate count.
A basic mandatory security procedure.
Scheduled for 10 p.m. And that count, if they had done it, it would have alerted them immediately to the fact that he didn't have a cellmate.
Or at the very least, it would have confirmed they were already shirking their duties hours before the most critical period began.
Moreover, that core supervision requirement, the 30-minute check.
Abandoned entirely.
Federal investigators confirmed it. Epstein was not checked every half hour through the night.
And the guards, in a documented attempt to conceal this profound operational failure, they later falsified the records.
They wrote in the logs retroactively that the proper checks had been performed.
Lying in official federal documents.
The consequences of this immediate misconduct were, they were detailed relentlessly in the Justice Department watchdog report, that OIG investigation,
The OIG found, and I'm quoting here, numerous and serious failures.
and documented instances of misconduct among corrections staff. It went so far as to suggest some of the actions were potential crimes.
The report explicitly identified 4 Bureau of Prison employees who had potentially committed crimes.
Primarily related to falsifying records or lying to federal investigators.
But the outcome for the 2 primary guards, Noel and Thomas, that just added another layer of institutional frustration for a lot of people.
They were initially charged by federal prosecutors.
For altering the records to disguise their lack of supervision, yes.
But they ultimately entered into a deferred prosecution agreement.
Right. And for listeners who might not be familiar with that term, a deferred prosecution agreement, it essentially means the prosecution agrees to hold off on pressing charges if the defendant meets certain conditions over a period of time.
In this case, the conditions were community service and cooperation with the investigation.
And after they completed that agreement, the charges were formally dropped by a federal judge.
So you have a situation where high-security federal guards, whose negligence directly led to a high-profile death, they only faced a community service requirement.
For lying on federal documents, it raises these profound questions about accountability within the federal prison system for catastrophic misconduct. The act of concealment received, comparatively, a minimal punishment.
And then there's the scene itself, which is complicated by verifiable physical and technological inconsistencies that have just fueled continuous public doubt.
Investigators did conclude definitively that no one, outside of the other locked-in inmates, was present on the SHU tier during that crucial time frame.
So that suggests no external party was involved from inside the facility.
Yet the technology that was supposed to confirm this narrative, it failed spectacularly.
There were 3 security cameras positioned outside his cell.
The very cameras that were supposed to provide clarity on the custody environment and the events leading up to the discovery.
And 2 of those cameras were reported to have completely malfunctioned during the critical period.
And the footage from the 3rd camera.
Officially deemed unusable.
So you have a complete verified breach of custody protocol. Guards are sleeping, records are being falsified.
And that's compounded by a contemporaneous and complete failure of surveillance equipment directly outside the inmate cell, in a high-security federal facility.
That combination negligence and technical failure, at the precise point of maximum vulnerability, that is a factual sequence confirmed by the public record. And it's precisely what makes the integrity of the subsequent official investigations so difficult for many to accept at face value, regardless of the ultimate finding on the cause of death.
This documented custody failure, it immediately ushered in a period of intense public scrutiny, especially regarding the medical evidence. On August 16, 2019, New York City's chief medical examiner, Dr. Barbara Sampson, officially ruled the death a suicide by hanging.
And the conclusion was that Epstein had used a sheet from his bed as a ligature.
However, the official autopsy revealed findings that immediately generated a fierce public contradiction among forensic specialists.
This is a key point. The autopsy found multiple breaks in his neck bones, specifically the hyoid bone.
Which is that U-shaped bone located in the front of the neck just above the larynx, the Adam's apple.
And this led directly to the core factual contradictions surrounding the forensic analysis.
Right. Dr. Michael Baden, a widely recognized forensic pathologist, he was hired by Epstein's estate to observe the autopsy, and he publicly challenged the ruling.
He pointed specifically to the severity and the location of the injuries. 3 fractures, 1 on the hyoid bone and 2 fractures on the larynx.
And Baden's argument was that these specific injuries were, and this is his quote, much more consistent with homicidal strangulation than a typical suicidal hanging.
He really elaborated on that. He cited his decades of forensic experience, his reviews of thousands of jail hangings, and he argued that finding 3 such fractures in a case of suicidal hanging was, well, almost unprecedented in New York State prison records over a 40 or 50-year period.
To really understand the weight of that argument, you have to understand the significance of the hyoid bone.
In forensics, right?
In forensic science, a broken hyoid bone is often, though not exclusively, associated with manual strangulation, where direct pressure is applied to the neck.
In a typical suicidal hanging, the body weight and the type of ligature used, they usually result in the break happening in a different place, or sometimes not at all, especially in younger people.
But the official ruling had strong medical counterarguments.
It did. Other medical experts, neurosurgeons, they all weighed in, noting that while the hyoid bone break is significant, it's not in itself sufficient proof of homicide.
And they emphasize that the likelihood of the hyoid bone breaking increases significantly with age.
Due to decreasing elasticity and increasing brittleness of the bone.
And Epstein was 66 at the time of his death.
Medical examiner Sampson, she stood by her ruling of suicide by hanging, firmly. She rejected Baden's public claims.
Her office maintained that the fractures were consistent with the type of suspension involved, and that the force generated by a fall or even just positioning in a hanging could cause such breaks, especially given his age.
But Baden also raised other documented physical inconsistencies in his report.
He did. He noted that the specific wound on the neck was described as central right in the front, not under the mandibles or the jawline, which is where you typically find the mark from a high suspension hanging.
And he also noted that the wound mark appeared thinner than the bedsheet ligature itself.
Which would suggest, at least to him, possible inconsistencies with the object officially cited as the cause of death.
Despite all these documented contradictions, the ME maintained the suicide ruling.
But, and this is crucial, the integrity of the scene was fundamentally compromised immediately after the discovery.
And that completely undercut public confidence in the reliability of the official investigation, no matter what the final conclusion was.
This is such a critical point of institutional failure. Prison personnel violated protocol by removing the body before the scene could be treated as a protected crime scene.
And the Bureau of Prisons protocol is explicit. It mandates that a death scene must be secured and treated with the same level of protection as any crime scene in which a death has occurred.
And they failed to do this.
They also failed to photograph Epstein's body as it was originally found.
A failure that directly prevented investigators from documenting the exact positioning, the tightness of the ligature, the relationship between the body and the cell, all critical visual evidence.
Evidence you would need to verify the dynamics of the hanging.
The Federal Watchdog Report, the OIG, it documented these lapses in evidence preservation with, striking detail.
Investigators failed to properly preserve evidence. They failed to run basic forensic tests like DNA or fingerprint analysis on the sheet used as the ligature itself.
And the cell was described as being in disarray.
Just think about that for a second. We have an institutional determination of suicide, but that determination was established at a scene that was immediately compromised.
Photographic evidence was missed, the body was moved.
And critical forensic analysis, DNA, and fingerprint testing on the instrument of death was never performed.
This documented sequence of investigative failure, confirmed by federal reports, is precisely why the official narrative struggles to maintain public confidence.
So if we step back from the custodial failures for a moment, we have to establish the methodology and the scope of the criminal enterprise itself.
Right, the enterprise that ultimately led to his 2019 incarceration in the first place.
The federal indictment confirmed charges of sex trafficking and conspiracy to traffic minors. It alleged he abused dozens of underage girls.
Some documented as young as 14.
And what's important here isn't just the volume of the crime, but the systematic methodology. This enterprise wasn't random. It was a highly organized recruitment operation.
It involved cash payments to victims, recruiting them under the pretext of getting massages that would, inevitably turn sexual.
And the use of a sophisticated victim-as-recruiter model.
This model was key. It was key to maintaining what the evidence suggests was a steady supply of new victims.
Right. Victims were incentivized, often with cash, to recruit other young women.
And that mechanism shielded Epstein and his associates by decentralizing the recruiting process. It turned victims into unwilling participants in the supply chain.
Crucially, evidence that was seized in the 2019 raids, it demonstrated that the criminal activity continued long after his initial 2007 plea deal, which we're going to get into.
Investigators found deeply incriminating material. Compact discs labeled with things like young name plus name.
Found in a locked safe in his Manhattan mansion. This indicates documented criminal activity continued through at least 2017.
So the enterprise was operational right up until his second arrest.
The legal fate of his key associate, Ghislaine Maxwell, is now a confirmed matter of public record, and it gives us deep insight into the structure of the operation.
She was convicted in December 2021.
On 5 sex trafficking-related charges, specifically including recruitment and the grooming of minors.
And she was sentenced to 20 years in federal prison.
Court filings, civil lawsuits, police records, they go back as far as 2005, and they all documented her central involvement.
The record shows she was a co-holder on a household bank account that was specifically used for petty cash withdrawals related to the operation.
And she was consistently named in civil suits as a co-conspirator. Specific victim accounts noted she allegedly approached a victim, saying they needed some girls to work at the house.
which directly links her role to the physical recruitment process.
And this brings us to a critical institutional failure that preceded all of the 2019 outcomes.
The government's role in omitting Maxwell from the original non-prosecution agreement in 2007.
During those initial negotiations, DOJ prosecutors later acknowledged that they were aware of Maxwell.
But they claimed that at the time of the MPA, they didn't have any specific evidence against her.
And the government's official stance on this, it evolved even further in subsequent legal battles. In a recent submission to the Supreme Court about the NPA, the government stated they were not even aware of petitioner's role in Epstein's scheme at that time.
At the time of the 2007 NPA.
Correct.
That claim of ignorance is arguably one of the most significant institutional failures in the entire timeline.
Because it stands in direct contrast to public reports and Palm Beach Police Department interviews that date back to the 90s and early 2000s.
Reports that documented her extensive central involvement with Epstein's public and private life.
Including reports linking her directly to the process of summoning young women to his homes and estates.
So this failure suggests institutional oversight that was either profoundly lacking or perhaps deliberate, a figure demonstrably central to the operation.
Identified in police files and civil lawsuits.
Was essentially ignored during the crucial plea negotiations that granted immunity to the entire enterprise.
And that oversight allowed the enterprise to continue without interference for another decade.
We should also briefly note the documented fate of another associate, Jean-Luc Brunel. He was a former modeling agent linked to the probe.
Right. He was found dead in a French prison cell while facing charges related to the probe, specifically the rape of a minor.
Which is another event that just compounded the complexity and the lack of comprehensive judicial closure for the victims and the public.
And to truly grasp the institutional shield that enabled Epstein, we have to dissect that 2007 non-prosecution agreement, the MPA.
This document is a foundational institutional failure.
It is. It effectively granted complete immunity to Epstein and, critically, to unnamed co-conspirators from any potential federal charges stemming from the investigation at that time.
The terms of his subsequent state custody were, arguably unprecedented in their leniency.
He served less than 13 months in state custody.
And that entire term included an extensive, highly unusual work release program.
And this work release, it was unlike any standard inmate release. He was permitted to leave the facility for up to 12 hours a day.
It effectively turned his jail time into a part-time inconvenience.
He could use his own driver for transportation, travel for medical appointments, and in perhaps the most telling detail.
He was referred to as a client.
As a client by the sheriff's office staff who monitored him. It just underscores the personalized, non-punitive nature of his detention.
The extent of this preferential treatment is further quantified by the financial records.
The Palm Beach Sheriff's Office received a payment of $128,000 from Epstein's nonprofit organization.
And this money was explicitly to pay for extra services and to permit deputies who were assigned to his work release detail.
And there were reports that some deputies assigned to him were even required to wear suits, not uniforms.
Further blurring the lines between custody and personal service.
But the core of the prosecutorial misconduct that defined the MPA, it wasn't just the leniency. It was the active, documented violation of victims' rights.
The entire agreement was negotiated and secretly executed.
Kept concealed from the victims for nearly an entire year.
And the subsequent legal challenge about this failure led the 11th Circuit en banc court. And that's a sitting of all the judges in that circuit, which shows how serious this review was, to later characterize the entire sequence of events as a, quote, tale of national disgrace.
And the deception wasn't just passive silence. It was active misdirection.
Federal prosecutors sent letters to the victims after the MPA was secretly executed.
Misleading them.
The letters stated that Epstein's case was currently under investigation, and they requested the victims' continued patience while they supposedly conducted a thorough investigation.
But the government was already negotiating his freedom and immunity while actively telling the victims they were still pursuing justice.
That sequence, it just raises a fundamental question about the ethical and legal behavior of the prosecuting office.
You have a documented timeline where state actors misled vulnerable individuals about the status of a case that was, in fact, already settled behind closed doors.
And then adding another critical layer to this systemic concealment, were documented efforts to actively obstruct oversight of this institutional failure.
The Department's Office of Inspector General, the OIG, repeatedly sought the authority to investigate professional misconduct specifically related to the NPA.
Meaning to investigate the professional conduct of the federal prosecutors who brokered the deal.
And the OIG stated explicitly that in every instance of a request for this authority, the then Deputy Attorney General denied the OIG's request,
specifically listing the Epstein case as one of those denials.
This deliberate blocking ensured that the professional conduct of the federal prosecutors who brokered that highly controversial deal remained completely shielded from independent internal investigation.
And if you look at the continuity of failure, the most profound consequence of the NPA was that it utterly failed to halt the criminal enterprise.
It should have ended the exploitation.
Instead, as confirmed by the evidence seized in 2019, sex trafficking continued through at least 2017.
The institutional failure of the NPA effectively granted a 10-year extension to the period of exploitation.
The ability of Jeffrey Epstein to achieve and maintain this kind of institutional impunity, it was inextricably linked to two things: his extraordinary wealth and the extensive, high-level network of influence he cultivated.
And his path to this wealth was unconventional. It lends credence to the mysterious nature of his rise.
He began at Bear Stearns in 1976, a low-level junior assistant.
But his ascent was meteoric. He moved up swiftly, became an options trader and a limited partner by 1980.
Specializing in advising some of the wealthiest clients on complex financial products and aggressive tax mitigation strategies.
In 1988, he established J. Epstein & Company. And crucially, he later set up the financial trust company in the U.S. Virgin Islands.
Relocating his primary operations there allowed him to take advantage of specific tax incentive laws,
which offered a dramatic reduction, up to a 90% reduction in his federal income taxes. This financial structure was crucial to amplifying his personal fortune far beyond what normal investment fees would have generated.
His reputation for managing complex finance was cemented through relationships with figures like the billionaire Les Wexner, the CEO of L Brands.
Wexner granted Epstein full power of attorney over his affairs for many years,
which meant Epstein had the legal authority to hire people, sign checks, buy and sell properties, borrow money, all on Wexner's behalf.
It provided him with immense, unfettered financial power and insight into the workings of a multi-billion-dollar empire.
And we also have to connect his financial mechanisms to broader market failures.
Right. Between 2000 and 2007, he was president of Liquid Funding Ltd.
This was a complex operation that pioneered expanding the type of debt accepted in the repo market, often using these complex, highly rated bundled securities.
The subsequent implosion of those opaque, complex securities played a recognized part in the financial pressures and the eventual collapse of Bear Stearns in 2008.
The scale of institutional and financial complicity surrounding his wealth was just laid bare when JPMorgan Chase settled a lawsuit with the U.S. Virgin Islands Attorney General
for $105 million.
The lawsuit alleged that the bank had actively ignored red flags and facilitated the movement of funds, thereby helping his criminal enterprise to prosper.
It illustrates that his criminal activities weren't operating in a vacuum. They were inextricably tied to massive, enabling financial systems.
And regarding the documented shield of immunity he enjoyed, we have a confirmed, publicly reported statement from the former U.S. Attorney Alexander Acosta,
who was responsible for that 2007 NPA.
Acosta stated that he was told, regarding Epstein, that he belonged to intelligence and to leave it alone because the issue was above his pay grade.
That is a remarkable statement from a former U.S. cabinet member, and it requires context.
This claim gains further texture from documented evidence suggesting an interest in operational security and leverage.
For instance, prosecutors found a fraudulent Austrian passport in his safe. It had a false name and stamps from Saudi Arabia and various European countries.
His legal team initially claimed this passport was necessary because, as an affluent member of the Jewish faith, he was supposedly in danger of being kidnapped while traveling abroad.
But the finding of the fraudulent document itself suggests a deeper level of planning and operational security beyond that of a typical high-net-worth individual.
Furthermore, sources familiar with his operations reported confirmed claims regarding potential compromat.
Compromising material used for blackmail or leverage.
These sources reported that Epstein compromised influential people by recording them doing things they wouldn't want made public.
And police raids confirmed the discovery of hidden cameras installed in both his Palm Beach and New York homes.
which suggests a deliberate effort to gather damaging material on powerful individuals. It provides a framework for understanding the exceptional impunity he received in 2007.
And it provides context for Acosta's statement about intelligence involvement.
Even Ghislaine Maxwell, despite her later denials of intelligence ties, was documented previously speculating that Epstein's planes were likely wiretapped.
For the specific purpose of gathering leverage, suggesting that the concept of information gathering on associates was openly discussed within their inner circle.
The documented associations he maintained, the fact of these connections, whether or not those high-profile figures knew anything about his crimes, clearly demonstrated the extraordinary shield of influence he successfully maintained for decades.
Public records cite associations with figures including 2 former U.S. presidents, high-profile technology leaders, financial titans,
and former Israeli Prime Minister Ehud Barak, who received significant funding from an Epstein-controlled charity.
The scale of these connections just underscores that the protection he received was a systemic failure. It involved institutional silence and the complicity of high-level figures in finance, politics, and law enforcement.
So we now return, for the final time, to the investigation into Epstein's death, synthesizing the confirmed findings and, analyzing the limitations that continue to plague the official narrative.
The Justice Department Inspector General's report, released in 2023, was clear.
It said the death was enabled by the jailer's negligence, misconduct, and outright job performance failures.
And simultaneously, the OIG strongly affirmed the medical examiner's conclusion of suicide.
However, even the government's presentation of evidence in the death investigation continued that pattern of generating issues and undermining its own credibility.
Right. Investigators confirmed that a segment of the surveillance video from outside the cell was inexplicably missing a full minute of footage.
It just jumps from 11.58.58 to 12.0.00.
That's a critical gap in the footage, and its deletion or absence has never been fully or credibly explained.
Furthermore, an investigative report by Wired magazine later determined that the released surveillance video had been modified,
despite claims by the FBI that it was raw footage.
This pattern of inconsistent evidence handling, manipulation, or mislabeling, confirmed by investigative reports, it just compounds the lack of faith in the overall process.
So if we synthesize the arc of this deep dive, the cumulative impact of institutional failure becomes the central, undeniable fact of the case.
Despite the official ruling of suicide and the confirmation from the DOJ and FBI that there was no secret client list, the documented systemic failures by state actors, they validate public skepticism.
They validate skepticism regarding the integrity of the official narrative.
Just consider the full weight of this arc. The initial failure of the FBI to fully investigate in the mid-90s.
The secret, misleading, immunity-granting 2007 non-prosecution agreement.
The denial of the OIG's investigation requests by the Deputy Attorney General.
The forensic compromises, like moving the body and the lack of DNA testing on the ligature during the 2019 death probe.
And the documented misconduct, the lying, the record falsification by the federal detention staff.
When accountability is repeatedly denied, when evidence is compromised, and when the institutions responsible for upholding the law are shown to have actively protected or neglected the individual involved,
it creates an environment where the public has every right to question the integrity of any official finding, regardless of the evidence presented.
And the victims themselves, they clearly reflected this profound lack of faith in the institutional response.
When discussing the Office of Professional Responsibility reports and the lack of accountability, one victim stated with immense clarity that the institutional response
felt very much like another slap in the face.
In terms of the final legal outcomes, Ghislaine Maxwell was eventually moved to a lower security federal prison camp in Texas.
An action that was notably questioned by Senate Democrats. They raised concerns that the transfer potentially violated established Bureau of Prisons policy, given her status as a sex offender and her role as a crucial witness.
Finally, one of the most significant structural outcomes came from the appellate court ruling in Driffer v. Maxwell.
The Second Circuit clarified a core judicial principle. Documents pertaining to mooted motions that were never fully decided because of the settlement, are still judicial documents.
And are subject to a presumption of public access.
And furthermore, the court held that filings related to motions to seal documents are themselves judicial documents.
To understand the gravity of that, it means that even the attempt to keep information private must be conducted publicly.
The arguments for secrecy become part of the public record. It reinforces a core tenet of judicial transparency.
The verified facts are tragically clear. The criminal enterprise was enabled and sustained not by a single accident or a failure of fate,
But by a cascade of institutional indifference, high-level protection, misconduct, and deliberate concealment spanning decades.
involving multiple federal and state agencies responsible for law enforcement and oversight.
That is the ultimate takeaway from this deep dive. The narrative isn't primarily about the cause of death, but about the systemic decay of the institutions designed to enforce justice.
The systems that were supposed to stop the crime prosecutors, federal oversight bodies, and correctional facilities either actively protected or passively enabled the exploitation for years.
And so the core lesson of this entire deep dive isn't the verdict on the death itself. It's the profound shift in judicial accountability that followed.
It is that appellate finding in Jeffrey Maxwell that filings related to motions to seal documents are themselves judicial documents.
So what does it mean for the future administration of justice when the effort to obscure uncomfortable truths by powerful individuals is fundamentally challenged by a court ruling demanding that the fight for secrecy must also be conducted publicly?
That mandate fundamentally challenges the use of the court system to shield influence in high-profile cases. It creates a lasting legacy of transparency where one once stood for impunity.